Good morning. Our first case is Creech versus Town of Cornelius, and we will hear from the appellant.
Mr. Chief Justice and Associate Justices, may it please the court. My name is Dwayne Jones with Hedrick, Gardner, Kincheloe, and Garofalo. With me is co-counsel John Behringer with McGangus, Goodlock, and Curry. We represent the defendants in this matter. I'd like to reserve 7 minutes of time for rebuttal. The elements for last clear chance establish a specific timeline for events to occur. And this analysis of last clear chance does not begin until the plaintiff has placed himself in a position of helpless or inadvertent peril. That's element one for last clear chance. After that, some new element for defendant's negligence must occur to continue with last clear chance. The negligence of the defendant, which triggers the last clear chance, has to occur after the plaintiff's negligence has placed the plaintiff in a position of peril. None of the cases cited in either of my briefs or in plaintiff's brief is inconsistent with that opinion or that interpretation. In fact, they all support it. The crucial error that the Court of Appeals made in this case is they sort of started the clock running for defendant to recognize the position of peril before the position of peril actually occurred. And again, in North Carolina, as we all know, it's contributory negligence state. And so the negligence of the defendants, for the most part, is canceled out by the negligence of the plaintiffs. Now again, once you get to the position of peril, whenever that position is created, after that, if defendant is negligent, either some new negligence or if a second negligence, or whether the original negligence occurred after the position of peril was created, then it's not canceled out. But that's not what happened here. But that's what the Court of Appeals, they sort of imposed defendant's original negligence upon them in the analysis of after the position of peril to determine whether or not last clear chance applied.
Well, counsel, if I'm the juror in this case and I heard the evidence presented, tell me what I do wrong if, based on all the evidence, I decide the position of peril initially is walking through the parking lot at 6 a.m. But I also decide that the driver has been and done this route many times. He knows he's doing the fish hook. He knows he's going to come around and come behind the pedestrian. The pedestrian doesn't know it. I hear the testimony about the light going into the person's eyes, and I say, given the lighting of the parking lot and his familiarity with his route, why, as a juror, could I not say, I think it was 12 seconds that he had? Why can't I find that as a fact?
Well, there are a couple things with that, Justice Riggs. First of all, as a juror, you shouldn't answer that question, because as a matter of law, the plaintiff's position of peril wasn't created until the truck turned. And that is, our case law is fairly clear, or very clear, that you can't be in a position of peril as long as you have control over your own circumstances. And there's no evidence that once the truck turned in, somehow plaintiff was not in control of his surroundings. He also had a duty to keep a proper lookout. He had a duty to, he's in a parking lot, which is a roadway, a place for vehicular traffic. So he had a responsibility to either keep himself out of danger, get on the sidewalk or whatnot. But at any rate, at no point in time, before even his own testimony, he was in control of, he could move out of the way. He was never in a position of peril. He always had the option to move out of the way, according to his testimony, until the truck began to turn.
It's my understanding that, and tell me if I'm wrong, that the really serious injuries to the plaintiff occurred when he was backed over.
Well, I don't know that that's clear. And
Well, let me ask you this. Why isn't it correct to say that if that's true, that the serious injuries occurred when the plaintiff was backed over, that the last clear chance to avoid the harm to the plaintiff was that moment before the driver backed over the plaintiff, and that the driver should have gotten out and looked at what he hit before he put the vehicle in reverse?
well, my answer is I don't think that issue is before this court. I do think it's a distinct issue. Those facts were mentioned in the Court of Appeals opinion, but the Court of Appeals opinion did not make any determination as to the backing up. I did not include that issue, did not ask this court to review that issue when I filed my petition. Plaintiff filed a response, but he did not include an additional petition. So I do think that is a separate issue. And one of the reasons, so again, I don't think the issue is properly before this court based upon what you granted when you granted the petition.
Can I ask you another question about that, though? Because it seems to me that if we're on the issue as it's stated in the petition for review, if we're having to determine, you're asking us to focus on what the starting point should be, but don't we also have to know what the ending point is? That is, when did the injury occur, in order to determine the relevant time period at which there might have been a last clear chance. And so it seems to me subsumed in the question that you have presented is an evaluation of when did the injury occur, and that here there's certainly, taken in the light most favorable to the plaintiff, an argument that the injury occurred when the backup happened.
Well, again, the reason that I think that it's a separate issue, and that yes, I think that you're what I'm going to argue to you is that the end of the analysis is when he first hit plaintiff, okay, and why you should not go beyond that point to determine the end point. Again, why it's a separate issue is after that point, I think that there's a whole different analysis as to whether or not there was a second occurrence of negligence or contributory negligence after the initial negligence. I don't think it's wrapped up into the last clear chance. Last clear chance is not a standalone issue. You can only consider it after Kenner's negligence and after Creech's contributory negligence. Now, again, I recognize the facts of the case. You know, I think that the facts of the case sort of may hamper my next statement, but I think that was Kenner negligent in backing over plaintiff? I think, again, you have to assess that. And then was there any point in time in that time where Creech was contributory negligence, and then you would get into a last clear chance there. I think that is the proper way that the issue should be looked at, and so I go back to my first statement of Court of Appeals didn't address that issue. I appealed or requested this court review what the Court of Appeals did, and I don't think it's been developed. I haven't briefed it. Plaintiff hasn't briefed it. So I do think it's a separate issue. I think that's my answer. I don't know if it satisfies you, but as an answer, I think I'm done.
No, it doesn't satisfy me. Just applying the principles of the last clear chance doctrine, how would you analyze? If there weren't, assume that I don't agree that it's not properly here, how would you analyze the facts of the case?
So that's where, again, I think that the evidence shows plaintiff was contributory negligent, and I think I'm trying to finish answering your question as well. We're not in a position apparently, always had control. He wasn't exercising that control. He wasn't exercising his duty. So he was always contributory negligent. His contributory negligence and Kenner's negligence, and we're not disputing that Kenner was not negligent. He never saw the plaintiff, but he should have seen the plaintiff, and we don't dispute that. His contrib negligence, Kenner's negligence combined, that creates the position of peril. Up until that point, yes, Kenner is negligent. You want to say he's negligent for 12 seconds, that's fine. But Creech is also negligent for 12 seconds because he did nothing to get himself out of the parking lot.
Yeah, but if you concede that Kenner was negligent for 12 seconds, then I think your argument under Watson just completely disintegrates, doesn't it?
No, because that 12 seconds of negligence is wiped out, erased by Creech's negligence along the same time. That's when you get to the last clear chance. So again, and that's just North Carolina. Defendant's negligent, plaintiff is contributory negligence, there's no recovery.
I guess what puzzles me is that I understand you to say, well, the defendant has to be negligent again after the plaintiff's contrib, right?
That's correct.
But yet you're saying we can't look at the actions of defendant Kenner after the plaintiff was struck, even though looked at in the light most favorable to the plaintiff, there's an argument that the backing over the plaintiff was additional negligence by defendant Kenner.
Justice Allen, that's just, I don't have an answer other than what I answered before.
Okay.
I don't think
Thank
that issue is before you. And again, in order to do that, I think you have stepped into another realm, another assessment of issues, which hasn't been done in this case, which is, did he have the last clear chance to avoid the first, at least the first collision? And that's what we're here today on. And I say, no, he did not. If you want to get into, was there a second element of negligence, contrib negligence, or last clear chance, those issues haven't been developed and they're not before you. They weren't developed at the Court of Appeals. So again, with respect to Justice Allen's position, to at least complete what I think the issue is, and I think to complete your question, at the moment that plaintiff is in his position of peril, which again cannot occur until the truck begins to turn. That's what the Court of Appeals found. And again, when you look at his duties, his responsibilities, and his ability to extricate himself, I think Color is the case that talks about the difference between helpless peril, inadvertent peril, and that neither of those applies as long as plaintiff is in control of his surroundings. So that's why I say, as a juror, you can't answer that question.
So assume that I agree with you and the position of peril is after the U-turn, but the jury still thinks that the time and the reasonable care is affected by the first 10 seconds. He's driving, he has headlights, he knows where he's going to be going. Like, you understand it. We're trying to understand what the jury could have decided based on the facts before it, and I'm not hearing an explanation of, without totally discounting any possible inference favorable to the plaintiff of what the jury could have decided, how I get to where you are.
Well, I believe that the case law is clear. All of the cases in the briefs are clear on the fact that the negligence of defendant is canceled out by the negligence of plaintiff. And again, you cannot ignore the negligence of plaintiff and what that did to contribute to the position of peril. You can't. So up until that moment, it's all washed out. That's what Mathis says. It's what Ingram says. And that was, the not carrying forward the original negligence was somewhat disputed in Exum, but they came out and said that's why I was careful the way I phrased it. If the original negligence happened before the position of peril, it's canceled. Contrib state, you never get to last clear chance. So the jury's never asked that question. So again, once you get to the moment that the perilous condition is created, after that, what happens? After that, does the defendant have an appreciable amount of time to avoid the peril? So everything that happened before, again, if you read those cases, I think it's canceled out. So you start the analysis at that moment of the perilous condition being created. Then does the jury get to answer that question? Well, sometimes they do if there's an appreciable amount of time. We have heavily relied upon Watson, where they determined that it wasn't an appreciable period of time. So at least in Watson, this court said, no, the jury, you can't answer that question.
Would you concede that it takes longer to slow to zero from 40 miles an hour than it would from 10 miles an hour?
Yes, I'll concede that. I think that's physical. But when you only had 2 seconds here. We stipulated that it was approximately 2 seconds. But even plaintiff's own evidence would suggest that it was less than 2 seconds, because when the truck begins to turn, he says that he was immediately hit. 1 to 2 seconds passed. It was all very fast. He didn't have time to move. He didn't have time to complete a thought. So we are at 2 seconds. And there is no case cited in our briefs that once the position of peril created went to the jury in less than 2 seconds. So again, as a juror, I don't think that you're allowed to answer that question. I think as a matter of law, no, there wasn't an appreciable period of time. I think that in Van Camp, they had an expert that talked about the general reaction time is maybe 1 to 1.5 seconds, maybe 2 seconds when it's dark. So he was in that range. He's in the range where we are. He was able to add a couple extra seconds, and Van Camp went to the jury because I think it was like 4 to 5 seconds. And so, yes, I think that as a juror, you don't get to answer the first question of you can't back the position of peril up until he turned into the parking lot. And secondly, you don't get that question if it's 2 seconds or less. And I think that's what Watson stands for. And again, I know Watson just says 1.28 seconds. And arguably, I'm asking for 3/4 of a second longer. But yes, I'm not asking this court to stretch this holding beyond any other holding from this court. And again, I went through all of the cases cited in the brief, and all of them, once the position of peril was created, they never applied the last clear chance until the position of peril was created. And in none of those cases was it less than 2 seconds. I think the quickest one was 2 to 3 seconds. Again, I got interrupted at one time, but does that at least answer your question?
Yeah, thank you.
So again, just to, I do think the original negligence thing is crucial, and maybe at least at some point of the time, I was finding it a little bit hard to understand. I mean, I think it's clear up until Exum in 1964, this court said basically, matter of law, original negligence is canceled by the contributory negligence, last clear chance can't apply. That was the stated law. Exum came along and specifically said, we disapprove of that language. We're not going to say that anymore. But I think it's crucial to look at why they said that. And again, just to reiterate the point that I already made, because you can take that phrase, the original, in North Carolina, the original negligence is no longer canceled out by the contrib for last clear chance, or the original negligence can continue into the discussion of last clear chance, which I'm not going to say that Justice Riggs, you were getting there, but I think that somewhere in that was the flavor of your statement. Couldn't the jury say what he did before and carry it forward? So again, when you look at Exum, they say that, these other cases say that it's canceled by the contrib. We think this is an inaccurate statement and we no longer approve it. Well, that sounds really bad for me since I just said that. But although the decisions in these cases, they reference Mathis and Ingram, one other case, but Mathis and Ingram are 2 cases I've cited. Although decisions in those cases were correct applications of the doctrine, in each of those cases, it is clear that what the court held was that to bring into play the doctrine of last clear chance, there must be proof that after the plaintiff had, by his own negligence, gotten into peril, the defendant discovered the plaintiff's helpless peril. And then it goes on to say that if the original negligence happened after the position of peril was created, like no negligence happened until the plaintiff was already in peril, then no, that negligence isn't going to be canceled out. But only that negligence is not canceled out. Again, so there has to be negligence afterwards. So yes, that within the time that the truck turned, was Kenner negligent in not recognizing plaintiff's peril? Did he have the time and the means to avoid the injury? If he did he avoid it? And again, I say, I don't know that he actually had the time to recognize, but he certainly did not have the time to react to it. Again, I just wanted to, because I think that what was in your question is also in the Court of Appeals opinion, and it kind of sees, to me, that's where it starts going off, and it, you know, again, I'm sure as Mr. Brooke is going to get up here and talk about, there's going to be all kinds of things to distinguish, but I think if you stick to that, which is what this court has said, I think the exceptions start to fall away. Again, in Watson, you know, another interesting thing about that case is the way that this court phrased it. On the facts before us, while defendant might have had the last possible chance to avoid the injury, she did not have the last clear chance. Again, Justice Riggs, going back to you, I think that the jury could conclude that he might have had the last possible chance. But again, the law says you don't get to ask that question unless there's evidence that he had the last clear chance. And I think, again, the subtleties between those two words, I think, are great, especially when you compress it into 2 seconds. What's possible and what's clear, the last is not that it's not the last possible chance, it's the last clear chance. I'm going to try in the last minute to go through some of the cases that have been brought up that you know, I think that plaintiff in his brief says that the Earl case, Earl v. Wyrick, said that it only takes a split second. Again, in that case, it's more than just a split second. Plaintiff's counsel seized upon that language that the defendant in that said, I only had a split second to miss it. This was 2 girls were walking. The defendant didn't see the girls, but one girl was able to get out of the way. Defendant said, only a split second before I saw her. Plaintiff's counsel wants to say that as a matter of law, a split second is enough. That's not true. In that case, I think there was evidence that the one girl was able to see the car, had the time to get out of the way, which therefore would say that the driver of the car had enough time to see the girls and also swerve. So again, I don't think it was more than a split second. It was greater. I'm at 6:44. I'd ask for 7 minutes. I think I'll reserve that time for rebuttal, unless there are other questions at this time.
Thank you, counsel. We'll hear from the appellate.
May it please the court, Christopher Brooke for plaintiff appellee Richard Creech. When Kenner passed Creech to make his U-turn to swing around to the payment drop box, he should have known that Creech's back was to him and that Creech was in inadvertent peril. At that moment, Kenner had ample time and opportunity to avoid injuring Creech. He had the last clear chance to avoid the accident. This court should affirm Judge George Bell's decision to instruct the jury on the last clear chance doctrine. The key moment here was the moment when Kenner passed Creech to make his U-turn. Common sense tells us that that is the key moment. Those facing traffic can know of and escape peril. if the truck had been coming at Creech on that morning, he would have known to step aside from that oncoming truck because Kenner was in front of him. But those not facing traffic do not know of and cannot escape their peril using reasonable care. Creech could not have known or acted to avert peril when Kenner unexpectedly made his U-turn to swing around to the payment drop box. The case law confirms that this is the key line. Clodfelter stands for the proposition that plaintiff is not in inadvertent peril from which he or she cannot escape using reasonable care when he or she failed to step aside from traffic that she was facing. Whereas Watson, which we've talked about a lot already this morning, and Earl stand for the opposite. Plaintiff is in inadvertent peril from which they cannot escape using reasonable care when they're not facing traffic. Defendants in their brief and this morning before this court do not meaningfully grapple with this key line that both common sense and the case law draw. They simply assert in their brief without citation that this line is somehow inapplicable. And this key moment here occurred more than 2 seconds before Kenner injured Creech. A jury could have believed that for multiple reasons. When Kenner passed Creech to make his U-turn, Creech testified that the truck passed him and then traveled some distance further into the lot, the middle of the lot. And everyone agrees that approximately 2 seconds passed from Kenner swinging back and striking Creech with his truck. The bottom line here is the jury could have believed, based on this evidence, that the truck was behind Creech for more than 2, maybe 3, maybe 4, maybe 5, maybe even 6 seconds. Elementary math points in the exact same direction. Kenner's truck, the testimony shows, passed approximately 15 feet to Creech's left at approximately 5 miles per hour. Kenner was driving, if he's driving 5 miles an hour, he's just going to be covering a little bit over 7 feet per second. So he could not cover 15 feet in 2 seconds. We also know that Kenner had to cover more than 15 feet to close that distance that morning. Creech was walking away from him the entire time with his back to him after Kenner passes him, until the moment before he is struck. If Creech is just walking 2 miles an hour, which is less than sort of the average rate of walking speed, it would have taken Kenner 3.5 seconds to cover 15 feet. But he had to cover more than 15 feet because he wasn't driving in a straight line. In the words of Justice Riggs, he had to do a fishhook, which is going to mean that he has to cover more than 15 feet to close that gap. All of this again points to him driving behind and having more than 2 seconds, even after he turns. 3 seconds, 4 seconds, 5 seconds, 6 seconds. And the jury also heard that the original strike is not what broke Mr. Creech's leg. Kenner broke Creech's leg by knocking him down, stopping his truck finally, and then backing over Creech's leg. Had Kenner been keeping a proper lookout when he was in the parking lot that morning, he would have seen him when he came into the parking lot, 12 seconds before the accident, when his headlights illuminate Creech. He would have seen him when he passed 15 feet to the right of him, when Creech is walking just outside of his driver's side window. And certainly when you make a U-turn, you don't make a U-turn and continue to face forward when you're making a U-turn. You turn your head to make sure that you're not going to strike someone. And even this morning, defendants' counsels acknowledged that Kenner should have seen Creech before striking him. So the jury could have believed that he should have seen him when he entered the lot, he should have seen him when he turned back, but he absolutely certainly should have seen him before he struck and knocked down Creech. At that point, he would have known, I've hit a person. I don't need to just stop. I need to not back up this truck. So there's a second, to Justice Allen's point, last clear chance here that the jury could have found separate and apart from the original strike. But you don't have to take the plaintiff's word for any of this. In the closing argument that the jury heard, the defense counsel argued it took the truck 5 or 6 seconds to make its turn. In their brief to this court, defendants also acknowledged that Kenner turning back to Creech took more than 2 seconds. From page 4 of their brief, defendants counsel writes, when asked at what point he felt the truck was turning back towards him, plaintiff responded, it happened so fast. He testified further that the truck's headlights would have been pointing in his direction for 1, maybe 2 seconds. So we focus on the 2 seconds here because we're looking at things in the light most favorable to the plaintiff. That means that the turn has progressed far enough such that instead of facing away from Creech, which Kenner would have been at the beginning, he's now turned his truck far enough to be illuminating him again. And he still at that point has 2 seconds until he strikes Creech.
Counsel, I'm sorry to interrupt, but you just indicated that there was, in the backing up, there was a second last clear chance.
Yes, Your Honor.
Your friend on the other side acknowledged or stated that that issue wasn't briefed. Where in your brief is there indication of a second last clear chance?
Yes, if you look at footnote 2 in our brief, the full argument is in there with citations, and it flows forward from the broader argument about what the law says in regards to a last clear chance. So the full argument is in our response brief to this court, and it's fully developed with citations, and again, flows forward from the general last clear chance case law, which is laid out previously.
Specifically, a second last clear chance?
Yes, footnote 2 asserts that there is a second last clear chance here that is independent and apart from the first last clear chance, which was the strike. Again, the Court of Appeals didn't need to arrive at that second last clear chance because there was a first clear chance. I expect that's why they stopped there. But that has no implications for whether that is before this court. And, of course, again, to Justice Berger's point, not taking just our word for it, defendants can't question, and don't this morning again, that Kenner should have seen Creech before striking him, meaning they should have not backed up and broken his leg. So the question that this court is presented with is, could Kenner have effectively used 3, 3.5, 4, 5, 6, far more than 2 seconds to avoid injuring Creech? A jury, of course, could and did find that a sufficient interval for Kenner to stop, maneuver, or slow his truck traveling only 5 miles per hour existed such that he could avoid injuring Creech. And I want to underline that last point for a moment. The standard that's laid out by this case law, for example, Clodfelter, is time to avoid injuring Creech, right? Obviously, this could mean Kenner taking his truck from 5 miles an hour to 0 miles an hour and stopping short of Creech. It could mean, hit him with the left front bumper. It could mean flicking his wrist very slightly and moving around him to the right. Would not have taken a big motion to be able to do that. But it also, in this circumstance, it could have meant just slowing or maneuvering sufficiently such that Creech wasn't injured. For instance, hitting the brakes, going from 5 miles an hour to 2 miles an hour. Maybe at that point, the jury finds that Kenner doesn't knock Creech down, so he can't be injured. He just grazes him. maybe can't fully move around him to the right, but he grazes him with the side instead of with the bumper so that he doesn't go under the wheels, right? There's a separate way of viewing this, which is that you could have a circumstance where maybe you can't fully avoid hitting him, but you hit him so softly that there's no injury that follows from that. Jury could find that, and if that's the case, the defendant had the last clear chance.
Well, as you've described various things that could have happened if the defendant had attempted to avoid the accident, doesn't that illustrate? I'm wrestling with as it's presented, the question whether 1 to 2 seconds is, as a matter of law, an insufficient amount of time. How do we answer that in the abstract as a matter of law without knowing the surrounding circumstances?
You need to know the surrounding circumstances. And this court's case law has never adopted some sort of artificial 1 or 2 second barrier to recovery. And I think that that's for very common sense reasons. If you have a car that's going 1 mile an hour or 3 miles an hour or 5 miles an hour, 2 seconds might be enough to stop that car. Let's say it's in an empty parking lot and it's able to freely maneuver. Very easy to do that. A truck going 75 miles an hour on a crowded interstate, 2 seconds is not going to be comparatively a lot of time to be able to slow or maneuver. So you need to be able to consider the broader context, and that's what this court's precedents have always said, that it's not just a time-specific consideration. And also, the PDR at bottom is about whether the trial court properly instructed the jury on a last clear chance. That's the issue that is in front of the court. The trial court the jury heard from Mr. Creech that his leg was only broken when Kenner backed over him. They heard in closing argument that that was a last clear chance. In the jury instructions, there were contentions of negligence, and one of the contentions of negligence for Kenner was that he backed over this leg, that it was a separate instance of negligence. This was fully before the jury, and certainly could have been a basis for their decision that there was a last clear chance. It's especially clear here that Defendant Kenner had sufficient time, as he should have been aware of Creech's whereabouts throughout his entire time in the parking lot. He saw him the moment he came into the parking lot, and he was in his headlights. He goes right by him, only 15 feet to his right. And again, when you're turning back, you should be looking back to see where he is at. It should have been very easy for him to keep tabs on Creech in the parking lot, which means, quite different from Watson, you don't expect a pedestrian to be on a highway. You do expect pedestrians to be in parking lots. You surely expect pedestrians to be in parking lots when you've seen them 10 seconds earlier. Defendants contend...
Well, I'm sorry, but to go back to the question about whether 2 seconds is insufficient as a matter of law, is it your view that in Watson that the outcome might have been different had the defendant been traveling at a slower rate of speed?
It could have been different. There's a different time interval in Watson as well. Instead of 2 seconds, there's 1.28 seconds.
Right. But what I'm sort of getting at is the time you have to react is the time you have to react.
Yes.
Regardless of how fast you're going. So we're just trying to figure out if speed really plays a role in this.
I think speed plays a role. Justice Allen, your question is well taken. There's obviously some sort of de minimis level below which you simply your brain can't process what has occurred, and therefore you cannot react, right? This morning, defense counsel has suggested, referencing the Van Camp case, that that's 1 second, right? And So if in Watson or here, there was only evidence that maybe there'd been a half second to see Mr. Creech, or 3/4 of a second, then I think our situation is appreciably more difficult, because we need to establish that there was a possibility of being able to process this such that I can press the brakes or such that I can turn the wheel. But here, and Watson presents for that reason, a much closer call as well, right? Because defense counsel has said this morning you need a second to react, right? And that would only give 0.28 seconds. But the standard is not just, the standard I think implicitly includes time to react, but it explicitly includes time to effectively react. And here, and that obviously, if you get above that sort of de minimis reaction time, which surely I think no one is contending we're not above that de minimis reaction time, the speed and the broader context is relevant to whether you can react effectively. And here, every fact sort of made this even if you just accept the 2-second window, which again, we reject, this was a circumstance where it was very easy to react effectively in a short period of time. Very low rate of speed, which means that you can stop quickly, you can maneuver quickly. An otherwise empty parking lot, not coming around a highway curve or being on a crowded parkway. Watson featured, again, a pedestrian on a highway. You don't expect that. Here, Kenner should have known about Creech's presence the entire time. So, just as Alan, sort of summation, would say that there's obviously a point below which somebody cannot react. No one is arguing we're below that point here, and the broader circumstances indicate that there could have been an effective reaction here.
So I want to ask you a question about Watson and sort of the implication of what we're being asked to do based on the question presented to this court. So I understand and read Watson, there's this as a matter of law language, but I also looked at the court in Watson taking into account the speed, the time of day, the mountain in the way coming around the curve or hill or mountain. And to me, that meant they took into account all of these different factors. My worry is if we start saying 2 seconds as a matter of law is not enough time under the third prong of the last clear chance doctrine, that I started doing the math. And then it was like, well, then going back to a situation like Watson going forward, if we use that 2 seconds as the metric, then it's really 16 seconds in Watson at a rate of 40 miles an hour. And that's not what we said in Watson, and that this sort of bright line mechanistic rule doesn't seem consistent with all of the things that a trial court is going to consider, like the evidence the jury is going to hear about speed and lighting and obstacles in the way. So am I right that this mechanistic as a matter of law is going to create a problem down the road and muddy the jurisprudence?
Yes, Your Honor. First, Watson is the typical fact-based analysis that this law has. It analyzes these 4 prongs based on the facts of that controversy. When the court goes to length to consider all of the relevant factors that you spooled out: 40 miles an hour, 1.28 seconds, coming around a highway curve, the mountain that's involved there. It is a deeply fact-based opinion. That is not surprising. It is built on precedent that repeatedly states that the last clear chance doctrine is decided based on the facts of the particular controversy. So adopting some sort of heretofore, unannounced, artificial rule would be a huge break from Watson and the broader last clear chance jurisprudence, which has been static and well established for the better part of 100 years. But also, Justice Riggs, to your point, it would, and going back to the point that I was making to Justice Allen, the analysis here is was the defendant able to effectively use the time and means to avoid the injury. Obviously, time is relevant to that, and I'll grant that there should be probably some sort of de minimis barrier where you have to be able to react. But defendants have granted we're beyond that barrier here, which means we consider other factors. And 2 seconds when you're driving 1 mile an hour is different than when you're driving 75 miles an hour. And we are far closer to 1 mile an hour here than to 75 miles an hour. I want to grapple for a moment with defendants' contention that, I just want to underline that 2 seconds here was enough, even granting that that's the amount of time that the defendant had to avoid Creech. Again, for the reasons previously stated, the jury could have found much more than 2 seconds. Also, that 2 second line doesn't grapple with, again, Kenner backing up over Creech's legs. But when I just underline, much easier here for Kenner to stop or maneuver his truck than in Watson for the reasons that we have talked about. And by defendant's own admission, 2 seconds was enough time for Kenner to react and slow or maneuver his truck, either to complete safety or in a fashion that avoided injuring Mr. Creech. A jury could conclude that even if Kenner only had 2 seconds, this constituted a last clear chance to avoid this accident. Your Honors, I want to make a final point before concluding. No one had a stopwatch or a measuring tape in that Huntersville parking lot on the morning in question. Maybe Kenner passed Creech to make his U-turn 3.5 seconds before running him down. Maybe it was 5 seconds. Maybe Kenner was 15 feet away when he passed Creech to start his U-turn, or maybe it was a little bit further. The bottom line here is that Judge Bell received the evidence and the testimony, and he found that in the light most favorable to Creech, a jury could infer facts consistent with each element of the last clear chance doctrine. And the jury received that evidence. It heard the testimony. It assessed witness credibility, and it went a step further. It held that defendant Kenner did in fact have the last clear chance to avoid the accident. This case, with its fine margins, we've spent the vast majority of this morning talking about no more than 10 seconds, and perhaps, 3 seconds, 4 seconds. This is why we have juries and why we respect the deliberations that juries go through. Kenner, just to close, Kenner passed Creech to make his U-turn more than 2 seconds before running him down, meaning unbeknownst to him, Creech was in a position of peril from which he could not escape using reasonable care for more than 2 seconds. Kenner, again, was well positioned to use that time to avoid injuring Creech. He should have known where Creech was the moment he entered the lot. A reasonable driver keeping a reasonable lookout looks back and again sees Creech when he makes his U-turn. And defense counsel this morning acknowledged that everyone agrees that Kenner should have seen Creech before he initially struck him. But even if it's 2 seconds.
Let me interrupt you there. My recollection of the argument in the briefs from your friends on the other side is that, yes, perhaps he should have seen the victim or the plaintiff when he came in. But I recall an argument that when the plaintiff saw the defendant come in, he should have gotten out of the way at that point. How do you respond to that argument?
Well, the jury found the plaintiff contributorily negligent, that he didn't keep a reasonable lookout, didn't take evasive action to avoid him. But then we come to the question of whether there was a last clear chance and whether there was approximate cause.
Well, and I understand that, but I'm trying to factor in the timing. Did the timing occur in this whole business of canceling out?
Yes.
How does that factor there? I understand the 10,000 foot level, but I'm down in the granular with this. The fact that they didn't get out of the way, does that in any way affect canceling out, the timing, or any of that sort of thing?
No, it doesn't, Justice Berenger, because once Kenner passes Creech in the lot and to make his U-turn to turn back, he has an entirely different level of information than Creech does. Creech continues to walk forward with his back to the truck. So there's no canceling out that occurs there. At that moment, Kenner always understood, because this was his typical move, Kenner understood, or should have understood, where Creech was and that he was in peril that he could not escape from. Creech, walking with his back to the truck, like the plaintiff in Earl that was struck, is not fully aware of what is happening behind him. He also has his earpiece in because this is between morning segments, so he is not hearing as well as he normally would, right? He has, by a mistake, according to the jury, put himself in a position of peril inadvertently that he can't escape from. The level of information that they have, the respective parties have, when Kenner goes around Creech becomes entirely different. So there's no cross-out that occurs here. Justice Berenger, I also want to clarify one fact here that defense counsel, I think, made in the brief and certainly made this morning. That there is, and it's not particularly relevant, but I want to underline this. There is this argument that Kenner could have just gotten onto the sidewalk, right? The sidewalk actually only covers the first 3 parking spots in the lot. Creech had actually not reached that point in the sidewalk. So it's not a situation where he's just gratuitously walking in the parking lot. There was no sidewalk for him to walk on. Now that, again, is not dispositive to whether there's a last clear chance, but I do think that it's a relevant fact for the court to keep in mind. Even if there was only 2 seconds here, that sufficed. 5 miles per hour, empty parking lot. For the reasons, Justice Berenger, that you and I just discussed, Kenner, unlike Creech, should have been primed to use that time effectively to avoid running down Creech and injuring him. Even a slight reduction in speed or a slight change of trajectory could have been all that was necessary. And to Justice Allen's point at the outset, set all of that aside. Defense counsel acknowledges that Kenner should have seen Creech before striking him. He should have known that what he had hit was a human being and that he should have just stopped his truck at that moment in time and not backed the truck up. So there is a second independent last clear chance. So regardless of whether the trigger is 2, 3, 4, 5, or 6 seconds, Defendant Kenner had the last clear chance to avoid the accident. This court should affirm Judge Bell's decision to instruct the jury on the last clear chance doctrine. Thank you.
Thank you, counsel. Rebuttal.
Thank you. As to this facing traffic issue, yes, I've said it's not applicable because it's not applicable. It's not applicable because of the law, and it's not applicable because of the facts in this case. When you look at the facing traffic cases, first of all, they all go to element 1, which is whether or not the plaintiff was actually in a perilous situation. We're not arguing that. He was in a perilous situation. But as far as this, and he had more information. When you look at those cases, there's somebody that's a plaintiff walking on an interstate. If you're walking towards the car, then clearly you know the car is coming to you. If you're walking with your back to the car, we don't know if you even have any idea that the truck is there or the car is there. So it's either you should have seen the car coming or you have no idea that the car is there. So what do the facts tell us in this case? Creech knew that the truck turned in. So it's not like the back to the traffic cases. He was aware, he had the information that I'm in a parking lot and a moving vehicle is also in this parking lot. So he's aware that the truck is there. So again, I think that's, yeah, I do not and still stand by the statement that the facing traffic cases, the import that they have in determining the perilous position are not relevant here. And again, both of these men, as soon as Kenner turned into the parking lot, Kenner had a duty to look out for Creech, and Creech had a duty to look out for Kenner. That duty, neither one of their duties ever ceased. Never ceased. Not when and we'll get into the facts later, but we'll get into them now. So when you look at the testimony of Creech, this is Creech's testimony. It's not my, I didn't make these words up. He's always aware of the truck. So I guess in some sense he's keeping his proper lookout. He's just not doing anything about it. He's always, I don't know that he ever says, except for maybe a split second, that he never saw the truck. Most of this is around 429, 430 of the transcript and continues on for several pages. But I saw him out of the peripheral and started tracking him, moving behind me, turned to see, saw the rear of the truck passing. Saw him passing, kept looking, recognized he was turning in my direction at the very end. I felt it turn. So he's close enough to this truck, not to get out of the way, but to feel it turn. As I looked, it started to turn, and my thought was, it's getting close. And before I could get that complete thought out, it was turning to hit me. Before I could even turn, my body went down. How much time passed from turn to hit? I thought this truck is getting close, and before I finished the thought, I was hit. So seconds. Okay, a second to a second and a half. Too fast to react. Creech's answer, much too fast. So I think Creech establishes a second to a second and a half. I don't even have to go to 2 seconds from the moment he was in peril to the time that he was hit. And again, he also testified that anytime he saw the truck, he just kept walking forward, didn't deviate anyway. So maybe he couldn't get up on the sidewalk. Again, he's aware that the truck is there. He's aware that the truck is moving. Statutes determine that he has a duty to pay attention to the truck and to get out of the way. And again, we go to Walmart, we're in the parking lot. I think it's reasonable to pay attention to cars and to get out of the way when they're moving.
To follow up on that point, based on the facts, the way I understand them, there's some distance when it does pass, the truck passes the plaintiff, that to me, in my mind, that's somewhat analogous to walking on a street and doing what you're supposed to do, but a car coming in a different direction in the other lane. You don't have to get out of the way of that car. Why would you have to do that here? Is it because it's the parking lot? What makes that a little different than a highway situation?
Well, again, they're only like 15 feet apart. And again, I don't know, again, I don't know the exact time. I don't think the evidence supports what plaintiff says, that the truck did not go to the back of the parking lot and make a complete U-turn. You can look at the exhibits of where the truck ended. The truck is almost horizontal to the street out. So he did not complete the turn, and he's about midway through the parking lot. So I don't know how this 4 to 5 seconds goes in, but I would still say if I'm walking in a parking lot and a truck has just passed me, as soon as I can't see the truck, does my duty end? Am I relieved of any other duty? And I don't think so. I think if you're in a parking lot, you have a duty to, especially, I mean, it's easier if there's just one other car. I mean, you know where that car is. And again, he said, I felt it turning towards me. And so if you start backing up, like plaintiff's counsel wants you to do, that maybe Kenner had 4 to 5 seconds to avoid this accident, I still maintain that Creech had 4 to 5 seconds to get out of the way. I don't know why his duty stopped. I can't see the truck. If I can't see it, it can't hit me. That's not reasonable to me. It's not the way I walk in parking lots. Maybe I don't think that I'm overly cautious. Just like Plaintiff's counsel says that, I got 15 seconds. Kenner expected him to be in the parking lot, yes. But if you're in a parking lot, again, and a car turns, you expect there to be a moving vehicle that can injure you. So I think that cancels out too. Out of time. If you have questions, I'll ask. Otherwise,
Thank you, counsel.
Thank you.